Your Honor, Your Honor, I request not to have to brief it. It's Title 24. It's a notice to produce, and honestly, Your Honor, Law School 101, it applies, and I just should not have to cost my client more attorney's fees to brief that very simple issue.
Okay.
It's not
well,
a just discovery issue.
I'm not going to brief. If you don't want to brief it, let's go forward with both motions now, and we'll figure out where the chips fall later on.
Your Honor, for the record, I object to going forward with the motion for new trial without Mr. Raymond producing what has been asked for in the notice to produce.
I got your objection. You got 35 minutes to do this.
Yes, Your Honor.
Because we kind of fritter away the first 25.
Yes, Your Honor. If I just may finish, it effectively reduces and eliminates my client's opportunity to present her motion for new trial in full.
That included notice of travel that they were not aware of during the course of this litigation. This litigation was
And you're including the voice, because we talked about that during the trial.
we talked about.
Is there something new on that front?
There is nothing new, Your Honor. The voice contract does in fact not have any schedule contained therein. That's what I understand. I do have a calendar that indicates Mr. Raymond's schedule for the voice that we're aware of. He is the pertinent dates that he's required to be on set for October, November, and April. Those are the 3 months. The reality is that Mr. Mayhew included in his response to yet another motion for new trial the fact that the dates that he was required to be on set in October, there were 13 of them. Only 5 of them were not during Ms. Foster Raymond's parenting. And so that would not have taken Mr. Raymond away from the children. He has not filed a notice of relocation as required by this court. He has not moved to Los Angeles. I believe that that's the issue that Ms. West presented before the court, that there is an intent for him to take his away outside the state. That is not true. Simply because she says it is not true. The voice contract is not relevant. It is not pertinent. We have said to you what his schedule is. I have a schedule that I can produce that indicates what is on set time is for the next several months.
She's asking for, and her notice to produce.
She contracts all documents. I have a schedule, we have the DERPA, those things we're willing to produce today.
Well, I'll ask you to go ahead and produce them. I'm not sure what else we can do about the production issue. I've never had a notice to produce for a motion for new trial, but...
Your Honor, under Title 24, the evidence code, it is pertaining to any and all hearings before the court, any motion, so it does pertain to the motion for the trial. Your Honor, I would ask that this hearing be rescheduled if, in fact, you are going to order them, and we request, again, for you to order them to produce all of the documents in accordance with this 4th notice to produce. Your Honor, with regard to the voice, Ms. Brown just went on and on about what his schedule is. I don't know what it is because I don't have those documents. Mr. Raymond has those documents. He has been privy to those documents throughout this entire litigation. With regard to your statement, Your Honor, we talked about the voice at trial. Your Honor, as set out in my motion for new trial, what Mr. Raymond testified to was he was in negotiations. He never mentioned the voice. He refused to do so. He was in negotiations for a show that would film either in Atlanta, New York, or LA. Your Honor, our position is he lied because the voice never films anywhere but in LA. So when he stated that, Your Honor, it was an intent to deceive this court into believing that he would actually be working in Atlanta.
I understand your argument. I just wanted to know procedurally what we should do at this point, and what my suggestion would be to go forward with the hearing on a motion for the trial with the, I guess, the presumption that what you're saying is true, and then you letting me know, how that would have changed things if we had known earlier, or how that should change things now.
Your Honor, I understand what you're saying, but let me tell you what the problem with that is. What I have to say, the presumption is, even if you take the presumption of what I have to say as being true. Well, when I asked him, Your Honor, about his tour schedule, He said he didn't have one. He said he did not have one. But 3 weeks later, he's referencing it in his own press release. He lied. Your Honor, your judgment of August 20th held him in contempt on custody issues. It held him in contempt on custody issues. In your judgment of August 24th, you specifically state, it is not in the best interest of the children to be on tour with him. And you state that during the time that he is on tour, at the beginning of 2013, the children will be with the mother. But Your Honor, that part of the judgment itself is inconsistent with the evidence, because your judgment on that relies wholly on him telling the truth and telling what his tour schedule is and what his schedule is. He hasn't done it throughout the entire litigation. So now he's rescheduled it for the latter part of 2013. But Your Honor, that's clearly not in the best interest of the children. You said it yourself, it wasn't in the best interest. But your order does not prevent him from taking the children on tour at that time or any other time. The judgment is wholly inconsistent with the evidence. It is wholly inconsistent with what is in the best interest of the children. It's recognized in you holding him in contempt regarding custody. It's recognized in you detailing that he did not turn over his schedule, and that it's not in the best interest of the children to be on tour with him. Your Honor, another ground to use the schedule, say he's even here to take care of the children. Absolutely, it's in the best interest of the children to lift supersedes regarding the custody or any other position. Your Honor, regarding the motion for attorney's fees, I'm going to rely heavily on the brief that we filed. Your Honor, let me specifically state regarding the motion, I have attached my declaration and also Mr. Aaron Cloud's declaration of state for the record. Mr. Aaron Cloud is not here, he is suffering from the flu. I have attached the declaration for the attorney's fees to date. I ask Your Honor to award attorney's fees under 1962, Your Honor. My client did prevail on 4 of the contempt claims, 3 of which were custody claims regarding custody. Your Honor, because of that, and because of the financial disparity between the parties, now, Your Honor, yet again, Mr. Raymond objected to producing. He has not produced financial information, despite this being the 4th notice to produce to do so. He has not produced it. My client not only has filed her DRFA, for domestic relations financial affidavit, it is attached as an exhibit to the motion for attorney's fees. In addition to that, Your Honor, I attempted to elicit financial information regarding how much he has paid his attorneys at trial. The objection was sustained, indicating that we would subsequently have a hearing in which to elicit that information. Now, Mr. Raymond's position is that my client should not be awarded the attorney's fees because there is no financial information. Yet again, an example of him controlling the evidence that comes in this court and then saying, hey, but you can't award it because the evidence is not there. It's unfair and inequitable. The financial condition of the parties is clearly disparate. There was evidence that was elicited at trial. Mr. Raymond indicated that he made $75 million in his 2011 last year OMG tour. In addition to that, his own testimony indicated that his financial condition allows him to charter a private plane at a moment's notice to provide for a village of people to care for his children when he's not here, which our position is he's not here 70 to 80% of the time, that he is able to provide for the team to plan schedules for the children. Your Honor, and I pointed out his testimony indicated, of course, he's not doing the planning of the schedules. And also to travel around the world for months at a time. His lifestyle indicates his financial condition. This court did recognize the financial condition of the parties when, in fact, Your Honor, it awarded Randy Kessler $25,000 in the prior case. These are 2 cases. My client brought her case in October 2011. The case that was brought by Mr. Raymond In January, our previous attorney was Randy Kessler. This court awarded $25,000 to Mr. Kessler. No objection, of course, by Mr. Raymond. There was no trial. There was no contentiousness. Now there's the objection. Mr. Raymond wants to apply Mr. Kessler's $25,000 in a separate case to prospectively. Can't be done. The law does not allow the application of attorney's fees awarded in one case to that of another. In addition to that, Mr. Kessler did not provide a fee statement indicating that that $25,000 was specifically for any contempt claims. Mr. Raymond wants this court to do so itself without providing any evidence of the reasonableness. Your Honor, Mr. Raymond objects to the grounds of reasonableness. But yet again, Mr. Raymond objected when I questioned how much he paid his attorneys, which is a method to determine whether or not these are reasonable. They did not produce not one paper. You have my affidavit, you have my declaration, you have the laying out of what time is spent on what issues. You have nothing contrary to it. As set out in my motion, Your Honor, it is sufficient. It is sufficient to determine the reasonableness of the fees. Your Honor also has the ability to determine it based on her own knowledge of the fees in the area. Your Honor, in addition to that, based on the misconduct by Mr. Raymond throughout this litigation under 915-14, we're asking that you award fees under that section in addition to 19-9-3. I have set out, Your Honor, in my amended motion for attorney's fees and costs, and the required brief and support, I have set out all grounds, and I stand on those grounds, Your Honor.